And all Indian standard times are always.
Okay, no issues, sir.
Yeah. People.
That will always happen.
Yeah. Yeah, let the number come to 50, then we will start.
We are already 54, sir.
Sorry, 54, sir.
We are 54.
Mohan,
ఈ డిపార్ట్మెంట్ కోసం అడిగాను అయితే సిరీస్ గురించి మనకి అదే
Sir, we reached 55.
Okay.
hello. Can you please keep your connection on mute? Okay, good afternoon, friends. Welcome you all again for the fourth day program. So, how many people have joined? 62. Okay, not bad. So, we have today at another renowned personality, Dr. Dumaneji. He was holding a very high position in the Indian Patent Office. He was the joint controller. Under his signature, so many patents were granted, both Indian and foreign inventors as a head of a Indian Patent Office. And Dr. Dumane is also, like many of us, has got the chemistry background, worked for industry, and then moved to Indian Patent Office and has contributed enormously for the growth of Indian Patent Office. A lot of policies, lot of programs he was able to implement very effectively. And whatever we are seeing today, uh, the rise of patents or the culture of IP filings or in general the patent culture as a whole, IP culture as a whole, has contributed enormously in considering his contribution to this field, and he is being a sought after person everywhere because the kind of knowledge he has got in intellectual property rights, and we are very fortunate to have you sir with us. And Dr. Dumaneji, he was also IPR Chair Professor. Now he is the Director of the Center for Intellectual Property Rights at Maharashtra National Law University, and a very renowned, very authoritative person in the area of intellectual property rights. I would say, among all the speakers what we have lined up, though they're all the best of the best, and I would say Dumaneji is above all of them because of his kind of a
Sir.
contributions he has made to the Indian patenting system, you know. So we are very, very grateful to you, sir, for accepting our invitation and sharing your knowledge with all our participants. It is it is a paid program. About 210 people have registered for this, paying the registration fee of 1,000 rupees, most of them, because students. For others, it was 2,000 rupees. There were about 210 registered participants. Because of the classes and other academic activities, they will be joining slowly and depending upon their convenience. But most of them are attending our classes because the kind of faculty we have drawn for this training program are really outstanding in their profession. They have been able to contribute excellently to the field. So I hope our students or participants are getting the benefit from all the experiences of wise people like you. And I welcome you on behalf of Andhra University and my team at DPIIT. I request you to take over and share your perspectives. Both the classes of today are being handled by Dr. Dumaneji, and that shows his passion. Generally nowadays, if anyone will ask, they always say we are busy here, there, but in spite of, though he is actually really busy, but he has spared his valuable time for us. Dumaneji, floor is yours. Kindly take over and share
Thank you,
your.
sir. Thank you. But see, now what time I'm having for two sessions is a
Yeah,
revised.
actually, it's up to 5:15, sir. Both the classes together.
Hmm.
As I think 4 o'clock, what is the program? As per the schedule, what we are given to them is 3:45. The first class up to 3:45.
Okay.
Uh,
Can it be extended slightly because now we are delayed
yeah, sure.
because this
Yeah,
content
yeah.
is
Yeah, sure. I think we are
Hmm?
already delayed by 15 minutes,
Okay.
20 minutes. Yeah.
So, thank you, sir. Thank you for kind introduction. You said so many high things about me. I am really that way. Thank you. Thank you, sir. So, shall I start now? I will share the presentation which I stopped. Yeah. Sir, is it visible?
Yes, sir.
Yes, sir.
Visible.
Okay.
Visible.
Shall I increase the size or it is okay for everybody?
I can go to the
Slide show.
slide mode. Slide mode. Go to the slide mode. Come to the
Presentation.
yeah, that's right, that one.
Okay, sir.
Yeah, click that one. Click that.
Good afternoon, all the participants and faculties, and thanks for my friend Dr. Purushottam. Uh, I understand that you have been given training on various aspects of patenting, including the patentable invention, non-patentable patent procedures, and then filing procedure, drafting, and all that. Now during the examination process also, you might have been told something about examination procedures. So we will start uh, from basics or just um, 1 or 2 minutes, and then switch over
Yeah,
to
basics have already been explained to them, sir.
yeah, yeah,
Wherever there is some
yeah, yeah.
requirement is there,
So
you
I
can.
will skip few of the slides like this.
Yeah.
So this is just to have refreshing your knowledge. This is patenting procedure, which involves from the conceptualization of the patent application, filing, with provisional or complete specification. It is published in the patent office journal, and after publication, so many things happens. What are those? After publication, that patent application is open for pre-grant opposition. It is open for licensing also, and uh, of course, people start approaching that person whether if that patent is valuable for getting benefit of licensing. But the most important thing that after publication, pre-grant opposition starts, and from there we are going to start today, and then the subsequent procedure takes place regarding grants after pre-grant opposition is disposed of. So, patent is not granted till pre-grant is disposed of, or there are other objections regarding patentability or patent law objections. So, whether there are objections in the patent law procedures, or legal objections, or formal objections, and then technical objections, or they are mentioned in the examination report. And if there is pending pre-grant opposition that time, then the examination report, which is submitted to controller, and before disposing of applications, the pre-grant opposition is also considered along with the final stage of examination. Now, why should have this opposition procedure? May I tell you that there are two opposition. Yeah, some noise is coming.
So the slides are not moving, sir. Changes.
Not moving. This one, they should. Okay. Now, yes.
Now it's moving, sir.
It's
Okay.
coming. Yeah, it's fine now.
But that is, see, in full scale working, it is probably some problem. So I will make it bigger here only.
Yeah. Visible, no problem.
This is okay, na? This is
Yeah,
okay.
okay.
Okay. So why should have uh, opposition system in the patents? Of course, it is available in all jurisdictions. And India, in the old Patent Act of 1970, which we removed and we embraced a new Patent Act in 2005. In the old Act also there was opposition, but it was after grant. Means after patent is found in order for grant, there was oppositions, waiting period of 4 months. Now in the new Act, we have two types of oppositions: pre-grant, means before the grant, as well as after the grant of patent. So this pre-grant opposition has been newly introduced in the Patent Acts with purpose, actually. And post-grant procedures have always been made somewhat stringent again by adding two new grounds also. So need of the opposition system arises because in India is committed to have transparent and fully law-abiding patent grant system in India. So we do not want to keep any doubt about the quality of patent or anything wrong happening in the grant of patent. So to take care of all such things, before grant, pre-grant opposition system is there. We have the transparency in the grant system. To enable members of public interested person, members of public or interested person, to provide to the patent office relevant information for the claim invention of granted patent that makes it ineligible for grant. Why this oblique is there? Because if it is pre-grant opposition, then any member of public, any person can provide information to the patent office which he thinks that it makes the patent grant ineligible, so patent should not be granted. Now, suppose patent is granted, thereafter, this patent should not remain in public domain, should not be enforced at all by virtue of something which the person from that industry or related to that patent subject matter will bring to the notice of patent office and request that this patent is an unworthy patent and should not be in the public domain, and therefore the post-grant opposition is considered by the controller, and if found suitable, the controller will revoke the granted patent. There are grounds for that. We'll slowly see that. Another object of the opposition system, if there are doubts about the ownership, who owns the patent, who is the applicant, whether it has been taken away forcibly from somebody, or there is wrongly obtaining the patent, all these things put doubts on the ownership of patent. So finally decide on the ownership of invention of patent accordingly. The patent system has law. Then, if there is any violation of national law or international law and it has been overlooked by the controller while granting the patent, that can also be taken care of by opposition procedures. And for the business or entrepreneurs who are working in the same field as of the patent subject matter, and they think that whatever patent is being granted or has been granted should not have been granted in view of the citations or the information he is having. So he can bring those information to the knowledge of patent office to stop such patenting. So this way, the patent opposition system is very useful for individual, for the society, and for the legal system also. Now, you know that for grant of patent, there are three criteria. Type and industrial application. Now, I have been asked to speak on anticipation. What does it mean? When certain prior art document, you know now the prior art is anticipating the novelty of the invention for which patent is being granted, has been granted, then those anticipating document must be looked into. So there are certain rules ruling by the courts when we say that the patent is not novel or patent is being anticipated by the prior art. When the invention is in public and is known to public before filing. Of course, it is prior publication of prior use and all those elements which come into picture along with novelty. Then this invention is anticipated. If in any invention or subject matter cited as prior art was kept secret, during the examination procedure, what happens? Prior document are notice, but those are not available. They are hidden or they are in different language. So the details of documents are not available to patent office. And even if they are just for namesake, they are there. So secret prior art is not valid for anticipating the novelty of invention. Suppose you have submitted thesis of your work to the university, and a competent authority is taking that or examining that, and it is in the custody of the competent authority. So as long as it is in the authority of the vice chancellor or registrar, whosoever it may be, then they are bound by secrecy, means they are confidentiality, and it is not said to be in public domain. So novelty is not being anticipated. But the moment it comes to self of the university or library of the university, then it is in public document, and such public domain and such thing anticipates the novelty. If invention is used for reasonable trial experiment, then and secrecy is maintained, then it is still novel. And if any document for that matter is available to public without any restriction, then that is anticipating the novelty of the instant invention. Then published prior document including patent specification anticipates novelty. Suppose you find that there is a prior publication in the patent, patent granted earlier. If it is similar to inventions in many respects, substantial aspect, then it will also anticipate novelty. Now, for the purpose of novelty and that there should not be any anticipation. There should be distance or difference between the prior art which is cited and your invention. And more this difference, this is the assurance of non-anticipation. To anticipate, suppose there is a prior art is related to similar subject, prior citations. Of course, you might have learned that for novelty comparison, by the patent office only single document is cited. And if that document contains something about the invention, but the clear and unmistakable directions are not provided in the cited prior art to perform the invention, and therefore such prior art is not anticipating the novelty of the invention for which patent has been claimed. And suppose somebody has filed provisional applications on the same subject, and your invention is lying before examination, then such provisional specification is not the prior art for any any application under examination. And but it will be anticipating if their prior art is provisional specification converted into complete, then it will have a date prior to your filing. Then that become anticipation. But suppose that prior provisional application is not followed by a complete specification, then it is not published in any time. So you are safe. So there is no anticipation. Then in under section 29 to 34, there is special provision. 29 to 34 of the Patent Act. There are special provisions in section 13 also. That what we comprehend that if invention is in public domain, then there is no novelty for that. True, but these provisions, certain provisions, as I said in section 13 and then section 29 to 34, are exception to that. So even if, say for example, the invention is published in pursuance of application before 1112, so that is not valid prior art for anticipation. If invention has been obtained wrongfully from the applicant and it has been published without his consent, then for the owner of the invention, these publications or like that, it is not the valid anticipation. So the rightful owner will always get a right of patent, although it has been obtained earlier by the wrong person. Similarly, if your invention has been displayed or exhibited or used with the consent of inventor, your consent, at an industrial or other exhibition, it has been notified by the government, and then subsequently it has been published in the proceeding of such exhibition, then also, and following this exhibition, you file the patent application during 1 year of such the date of exhibition. See, your invention has been exhibited or displayed exhibited, true. But within 1 year, you have to file application for patent before patent office. Then novelty is intact. There is no anticipation, although it was displayed or exhibited in the examination. The special concession. The second concession is that if you have read the paper in the learned society, say for example, you have published or read paper in the Journal of Chemical Society, and then it is also published in the proceedings. And after such event, you are again same condition that you have filed patent application within 1 year, then also novelty is intact. This is not known to many persons, and people are confused. There are increasing cases nowadays about what shall I do if my invention has already been published and have I lost the right to make application of a patent. Then you have to tell the patent office that, look, I have made application within 1 year of my reading the paper in that society. That is sufficient. You have to show the proof. Then that objection goes away. Third thing, invention is publicly work in India any time within 1 year before the prior data, only for reasonable trial. Sometimes what happens, invention is for device and you have to take test of those. How you will take test? For example, you have to take the improved test of improved car or some radiator type of things which you have used, or some, say for example, the electronic mechanism in the car. You have to test it. How you will take the test? By running car on the road. Now there was a famous case in USA. He has developed a device which will not allow the temperature of the car beyond certain limit, and it will radiator of course, and it will safeguard the car. Now to take test of the car, it was essential to take the car on the road for running. Somebody knew about this, that there is a invention. This car is running with new invention, or which patent will be applied for. He launched opposition to that it was in public domain, patent should not be granted for that. But the court held otherwise. Court said that nobody, no member of the public had any chance to stop the car, open the bonnet, and see what is there inside. Therefore, that invention was not made public. So that is one such case law there. So secrecy has been maintained. You have to take care if you are using such system, such display in the on the road. Now we come to pre-grant oppositions. Okay. So having discussed anticipation, which are not anticipation or which are anticipation, it is also one of the important ground in pre-grant opposition, for which you might have studied in the patentability aspect and non-patentability certain few things about this. Now we go for pre-grant opposition. Pre-grant oppositions, if available on the record, as I said, taken into consideration by the controller along with examiner's report of examination. So it is not, it is to be kept pending, but now it is, the procedure is that if the patent examination report has come to the controller and he is now required to decide upon whether the patent should be granted or not, or refused or amended, and pre-grant opposition is pending, he has to dispose of the pre-grant opposition before he proceeds for grant or refusal. So I am looking at the second stage. Okay, this one. This pre-grant opposition is referred to as third-party representation, because legally this is not a full-fledged position. Prior to 2005 Act, in between, very limited grounds were made available for launching the opposition before grant. Then people say it is discriminating. Other grounds should also be made available, like post-grant opposition. Now, the grounds of opposition in pre-grant as well as in post-grant, they are similar, except that the pre-grant opposition, the word is application, patent application, as claimed. And in post-grant opposition is a patent granted. This is a difference. Otherwise, subject matter of grounds is same. Therefore, the pre-grant opposition is always called third-party representation in the process of patent grant procedure. Now, who can file pre-grant opposition, before grant of patent, and after publication. So any person may file pre-grant. There is a form 7A. It was introduced very late. There is in 2016 amendments. Before that, there was no form, and it is to be filed at appropriate office. What does it mean? Suppose you have made application for say your Andhra University, you have to make application in Chennai. So any pre-grant opposition from India, he has to file pre-grant opposition in Chennai office only, right? That is section 25(1). This can be filed at any time before grant, but after publications, because unless the application is mandatorily published under section A or other publication in that section, no member of the public has a right to examine the patent application before publication. Therefore, the pre-grant oppositions is allowed to be filed only after there is a publication of application, but it is not sufficient. Request for examination, which can be filed by the applicant or any third party also. So these two conditions are to be made. There should be publication of application, request to be filed, and there is no fee required for this purpose. And while filing the pre-grant opposition, the opponent shall submit a statement and supporting evidence, statement of opposition, as why is opposing the grant of the patent. You have to elaborate grounds, and for that purpose, you have to give evidence in the form of citations or other document that it was in prior use and all that like that. So supporting documents, supporting evidence and statement must be furnished, and he has to mention that I request for hearing. So request for hearing is also required. And this statement and evidence means the copy of the opposition must be sent to the applicant for patent also. So applicant is not kept in dark about the pre-grant opposition which has been filed in the patent office. As you know, and you might have been told that after publication, patent is not granted before the expiry of 6 months, right? So after publication and up to 6 months is the safest period to lodge pre-grant opposition. It is sure that patent has not been granted till that time. Of course, you have more time till patent is granted for filing pre-grant opposition, but 6 month period is always available. And thereafter, you have to keep watch as to when patent is likely to be granted, and you have to keep vigilance. But up to 6 months, that is not the case. So what is the procedure for deciding pre-grant oppositions? Controllees of the opinion, after receiving the statement and evidence from the opponent, if the controllees of the opinion that pre-grant opposition has merit, it deserves attention, and the application shall be refused or complete specification require amendment. There are at least 3 possibilities only. So pre-grant opposition is valid, or an application can be refused on their ground, or patent application can be amended in view of the citations made in the opposition statement. He shall give notice to the applicant to along with a copy of representation, and after receiving such notice, the applicant has to furnish his reply as to what he has to say on the grounds and the objections raised by the opponent in his statement. He has a paragraph reply he has to provide to the controller that the opposition is invalid and patent should be granted to the applicant, like that. And this action must be done within 3 months, and the reply copy shall be sent to opponent. So although this procedure thereby invariably all the pre-grant oppositions are heard, means both parties are called, which is not necessary as per the provisions of the Act, but in view of the natural justice, both the opponents and applicant are called after receiving the reply for the applicant and to hear both, to um, allow the submission to be made by both the parties and conduct after such hearing and consideration of what is before the controller now. The controller has statement and evidence filed by the applicant. He has representations made by the opponent and evidence he has filed. This is another thing he is having. And then third thing, he has got submission by the party during hearing. So based on all these three things, what controller can say? I hope the slides are moving and I am visible and audible sufficiently.
Yes, yes, sir. Moving. Go ahead.
Thank you. Now, after considering all these three sessions, that is these things, as the submission made by the parties, opponent statement and evidence, and the reply statement by the applicant. The controller will decide, means he will either reject the representation and grant the patent, or he will require the complete specification and other document to be amended by the applicant to satisfaction before the patent is granted. Because look here, the opposition has something to be considered, but still the patent application made the applicant has again something which can be granted. So higher media is that the patent application should be amended, as the controller says. He will direct the applicant to amend, remove some claims or like that, or disclaim something which has mentioned in the specification or something like that. So the way out is taken to amend the applications and the amended specification is granted patent. Second thing. Third thing, he will refuse to grant the patent. First thing, he will reject the representation. So there is no substance in the opposition. Or he will accept the oppositions and refuse to grant the patent. And then when he refuses to grant the patent, then speaking order under section 15 is to be issued by the controller. What is speaking order? Means just mere statement that I am refusing the patent under section 15 is not sufficient. He has to go by ground wise, why this ground is not applicable, ground is applicable, and why this is killing novelty, all such things. So speaking order, detailed order, he has to pass under section 15. And while disposing this pre-grant opposition, he is disposing the application also. The fate of the application is completely final after pre-grant opposition decided. Simultaneously, grant or refusal is also finalized. Now, suppose somebody has filed in the name of pre-grant oppositions, the oppositions, but that has been issued by the patent office after patent has been granted. So, what is the duty of the controller? He will inform such opponent and he will return the opposition to him that now time is over. I have already granted the patent, and if that opponent who is coming after the grant is interested person, then he may file post-grant opposition also. Of course, filing post-grant opposition is always open to any interested person like that. So we'll skip that. We have explained enough way. Now, what are the grounds for pre-grant opposition? As I have already spelled, that the grounds of pre-grant and post-grant oppositions are similar in wording, except that here word invention or application has been mentioned. There, word patent is mentioned. So we will see in detail the grounds here. So these are the from grounds A to K. Invention is wrongfully obtained from other person. Prior publication in India or elsewhere, prior claiming and prior public knowledge or use. So first is separate ground B, C and D. They pertain to the fact that there is no novelty in the invention. This is what the opponent is claiming through ground B, C, D. Then comes ground E, which the opponent claims that there is no inventive step present in the invention. So all these efforts are that patent should not be granted. So he will elaborate his grounds of opposition with certainty and all that. Then comes a ground F. It is not an invention or not patentable under the Act. So basically, see, basic full requirement are not met with, and under Section 3 and 4, the patents cannot be granted on certain provisions. Those out of some provisions may be applicable to these inventions, at least from the side of the opponent. They will say that patent should be refused on such a ground. Then ground comes insufficient and unclear description of method of working. So you know that is patent acts, and he will cite this ground. We'll see this in detail. Then failure to disclose largely regarding foreign value. All this. So without we'll go ground by ground now. Important ground is wrongfully obtaining the patent. How this can happen? Suppose you are working in a laboratory. This is actually the case which has happened. And there are all types of elements available in the research field also. The other person, while looking and while viewing you doing some experiment, may duplicate your experiments, and then on the same subject matter, research may be stolen by him, and he will file patent application in your name. This is one thing. Or another thing, for example, you are working as a research student. It is in Delhi patent office. This has happened. That fellow has completed the thesis, submitted thesis. Then he has gone to his home place to take rest, etc. Meanwhile, his guide filed patent application in his own name without giving any credit to the student. He thought that student, why should I should give credit to student? A couple of years before. Then after coming back, the student took objection to this. Naturally, he should take that it is my patent and it is wrongfully obtained from me by my professor, and patent office rightly allotted or transferred the ownership to the student. This is because the rightful owner of the patent application is the researcher, not the guide. And unless you are assigning your invention to your employer, then employer is the owner, of course. And if you are not assigned, they do not ask you to assign, then you are owner. The university has specific provisions that as soon as you are enrolled as a research student, they will take undertaking from you that all the IPRs created through this work will be owned by the university. In that case, you are not owner. But suppose in a factory or in any enterprise, in a multinational company or any national company, you are working, and you have made research which is not connected to your work in the enterprise, then that research work belongs to you, and you are owner of that, and you can file patent application. That is not wrongfully obtained. And in such case, when it is obtained wrongfully, after patent is granted, then and it is opposed by the rightful owner, then patent will proceed in the name of rightful owner. Then after this decision of the control, you have to apply for transfer of this patent in your name in the prescribed form of fees in 3 months of these decisions, and then he will make the entry and the register of patent like this. Sometimes what happens during this episode, part of the invention is only copied or filed, which belongs to rightful owner. Then the controller decides that which part has been owned by the student, for example, owner, then that part will be excluded on the new application, and the student will be allowed to proceed ahead, go ahead with his inventions. So there will be 2 separate applications can be filed when only part has been obtained. Now another case means this is not the related to opposition per se, but the procedures of opposition are applied to this phenomenon. What happens if somebody has contributed as an inventor in the laboratory and in the research work, and he is not given due credit, means his name has been omitted and not included as applicant for patent, then he has to make application before patent office that on this application I am an inventor and my name should be included, right, with a request, and he has to make such request in Form 8. Now, such request, which is for the introducing about including his name as inventor in the patent application, is how it is decided. It is taken care of by the controller by applying the procedure of patent grant procedures, opposition procedure, like giving notice. And this procedure, as we will see, that this opposition procedure is described in patent rules 50A to 50A, 55A, and 57 to 63. So all these proceedings are applied to decide this matter also, which is regarding including the name as inventor. There was a famous case of wrongful obtaining, which I will not discuss with you. And it is decided by Bombay High Court. The opposition by the research, the opponent was a research assistant, and he raised that the invention for which the application has been made is mine, that it has been wrongfully obtained by other persons. Ground he raised was that, of course, wrongful obtaining, and request was made to mention his name as an inventor. The matter went to court, and the court observed the following things, which is very interesting. The opponent, the research assistant, his job was that of laboratory technician, and he was not of scientist. That job was not of scientist. He could not produce before the court any substantial evidence or witnesses to substantiate his claim as an inventor. Third thing, court give the opinion that for naming as the inventor, he should have provided ideas to produce germ of inventions and made intellectual contribution in achieving the final result of the research leading to a patent. But he has just assisted the main researcher or help in some other way which are not counted under this, that producing the germ of invention or making intellectual contribution. Those and his help and assistance would not fall under this category. One or more person merely involved in carrying out experiments does not mean that they are inventors. And these principles generally are now also they are applicable for when such matters comes either before patent office or even with the competent authority to decide the ownership of the patent applications and how to proceed after that. Then court said firmly that inventor is the actual deviser of what is being claimed. So the opponent failed to prove the ground of wrongfully obtaining. So that fellow was not given the right of patent. Now next ground, that is prior publication, prior claiming, and prior public knowledge. I think they have been explained to you. I will just summarize this, that these are part of novelty of the inventions, and opponent claims that there is novelty. That means he says that there is a prior publications in some patent literature and non-patent literature, and he will cite that worldwide. Then there is a prior public use in India. He will cite the proof if there is prior use by some documents. Then the invention has been claimed in earlier applications, and this is called prior claiming, but it is published later on, but it does not matter. He has filed earlier, so it is a prior claiming, and the new applicant cannot ask for right for that inventions. We have seen this. I'm not going to repeat this again because in anticipation, similar things are there. Now, there is important case which IPB decided, and it was held that to defeat the novelty, the appellant should show that an earlier document disclose all that the patent is seeking to patent, and that each limitations of the claim invention is found in a single prior reference. That is, as I said, single document is compared for claim novelty. Then similar thing, lack of inventive step, you might have been explained, as your earlier speakers, that what is inventive step, and when we say that there is no inventive step. So I would like to pass. Is it necessary to explain this? Somebody wants? that I should discuss this?
Yes, this is very important slide, sir. You just can spend
Okay.
2 or 3 minutes.
See, when we say that when there is inventory step, as per section 2(1)(j), your invention should have some features which display some technical advancement or economic significance or both. One part. Second part is that features should not be obvious to persons in the art. Now, when opponent says that your invention does not have inventory step, so he would like to say that because for inventory step, whole prior art is considered for judging inventory. It is not like the novelty. So, opponent will try to get as many documents, and by mosaicing those documents, he will say that, look, I have arrived at the same invention which is being claimed. So, this invention is not having the inventory step. So, to escape from this objection, what is required? There is prior art. Many cases, the arguments of the opponent is not accepted. So, although he has mosaic and proved something, some statement, because there are some loopholes like that. So, what is necessary to avoid and to escape this objection? The difference in the prior art, technical difference, I mean technical ground, etc., and your invention are such that this objection is not valid for inventions. It means such this difference is substantial and significant, technically significant. Now, when such objection is none, the duty of the attorney of the applicant that this difference, this similarity between them are um, not there because this, for example, the citations you have made for the aeroplane which were applicable to aeroplane, and your invention is a small machine. Those will to the invention of small machine. Such thing happen many times. All the objections and mosaicing of the citations from the prior art to kill the inventive step are not valid always because that prior art is differently applied to some other thing. It is not valid. It is applied in a different range, whatever is prior art. So it is always possible to escape from the objection or inventive step, or at least you can just disclaim some portion and go ahead with the inventions. So certain example that if there is no inventive step, when the invention is in juxtaposition of known devices, and you are keeping those devices together to get a new system. System is new, it is novel by virtue of joining these integers. But there is no interlinking of the activity or some technical advancement by virtue of their working together. So it is mere juxtaposition. So there is juxtaposition, there is no inventive step. Then your invention lies in only providing equivalence to the known. For example, in a say machine, you are replacing the motor, a large motor with a small motor. Everything other remains same. Although efficiency may be increased by say few percent, but it is not sufficient. You should show that the efficiency and the say life, all the ease of doing, etc., are much increased by virtue of this because of the interlinking of the actions between the integers. Mere providing equivalence is not sufficient. It will attack the obviousness, right? Sometimes what happens, there is a prior art and there is inventions. Now by filling this gap, of course, then invention can be arrived. So invention lies in the filling the gap. And such filling in the gap is obvious to a person who is skilled in the art. He will immediately understand that if I do this, invention is complete. So invention is lacking in obvious, in inventive state. For example, there is an invention building the structure made from aluminum, for which its claim has been made. And prior art is there a structure of lightweight material used for the same purpose or similar thing. But there is no mention of aluminum. Now, any skilled person in art will will understand that lightweight material is there, aluminum is lightweight material. If I use that, I get invention. This is the example of lack of inventive states. For industrial applicability, uh, he will change that the invention is not applicable. Or he will say that opponent will say it is method of treatment, which is not amount to industrial applicability. Or the application part of the invention has not been mentioned or stated very clearly. It is mentioned in this very speculative or in the frivolous manner, like a compound may be useful in treating disorder, a compound has useful biological properties, etc., without giving exact application of the invention. Then the opponent may succeed on this ground of industrial applicability.
Sir, can you please go to 24 slide number, previous one? Just a small doubt.
44, 24.
24.
Yeah. Yes, sir.
Yeah, in the last sentence, you have given example.
Yeah.
Uh, Building the structure made from aluminum
Similar structure.
and structure of lightweight materials, but does not mention aluminum.
Yes.
So whether it is qualifies for inventive
No.
step or the
It
novelty,
is, it is novel.
uh,
It is novel, but may not be inventive. Why so? Because similar structure you are using by using aluminum and lightweight material metal is mentioned. And any person skilled in the art, that is test for inventive step, will comprehend that I can use aluminum to get this.
oh.
So control will raise the objection. It is obvious to the person skilled in the art. Think of the second part of the definition of inventive step.
So though it met the novelty part,
Yes,
but
yes, yes.
it failed in the inventive step
Yes.
component.
Novelty is determined first and inventive step is thereafter. It is not necessary that the difference which is between the invention and parrot is there, but that difference is not substantive technically eligible to make invention qualified for inventive step. There are several cases like that. Okay, sir?
Okay, sir. Thank you.
Yeah. And of course, the second part of this, that it is not invention as per section 3, you have been told of very elaborately in this, I hope. So, in section 3, if there is any doubt, you can ask me. So, otherwise, we will skip this portion because the grounds under section, any ground under section 3 can be taken for opposition. So I hope there is no doubt. They have explained nicely to you in earlier lecture. So I can skip this.
Yes.
Okay. Next is the complete specification does not sufficiently and clearly describe the inventions or the method by which it is to be performed. So you are aware or you have been told that there is a section 10 in the Patent Act. It speaks about how your complete specification should be there, how it is written, so that it is sufficiently described. Section 10 says that every complete specification shall fully and particularly describe the invention and its operation or use and the method by which it is performed. Right? Of course, if this requirement is not met, an opponent has pointed out that invention is not described properly, it lacks this further requirement also, it has not given the best method, means it lacks in the methods of use and operation, first thing, and it lacks, there is no best method given in the inventions, like this. So, it is insufficiently described. Or he will say that the claims are not proper, claims are vague, something like this. All this comes under these objections. Or then, in case of biological material, the deposit of biological material has not been made properly as required for this under section 10. Or then, and that date of depositing biological material is also not proper. All these things come under this ground of insufficiency of disclosure. Now, complete fiction must disclose the invention that we have seen, because you should always remember, of course, this is very subjective way of what I'm saying, that when invention is, say, uh, comprehensible, is understood, invention to be understood by persons in the art. That is what invention is addressed to. Now, if the part of invention or novelty is such that, and it is easier to understand the invention for the persons in the art, the obviousness objection will always be there. And that is a difficult objection to get rid of that in actual practice. And therefore, you have to submit some documents or say citations how the patent has been granted uh, in view of the lack of inventive step, and how these objections was overcome. The next ground is failure to disclose or falsely furnishing the information of corresponding foreign filing, section 8. This requirement must be fulfilled, and all the applicant for patent is under obligation to give information to patent office. Yes.
Sometime back you mentioned to me marine living resources the patent application law.
Yeah.
Sorry, sir.
Anything for me?
Sorry, sir, he is on other call.
Okay. You see, information on corresponding filing or filing by the applicant in foreign countries must be given to the controller, that information. And suppose controller requires specific thing, that also to be given within 2 months of such request. So that is mandatory. And the objection, many times it is there that the foreign filing details have not been provided or have been given late by the applicant. This is one of the ground of oppositions. The next is source of geographic origin of biological material used in the inventions. What happens when you use the biological material for your invention? Then you have to mention the source. Of course, this requirement is not for the application coming from abroad, right? When you are Indian applicant and using biological material, you have to mention from where you got this, right? And then the general requirement for all biological material is that when you are using the microorganisms for filing patent applications of some say mutated microorganisms, etc., what is that, then it may be possible that these microorganisms is not easily available to public, and then they are required to be deposited in the international depository within specific time, so that other researchers can take benefit of that. This procedure should be complete at the time of filing of application. Opponent will say that this procedure has not been followed, there is time delay, it has not been deposited, or like that. So this is one of the objections by the opponent. Then last is invention anticipated by the knowledge, oral or otherwise, available within any local or indigenous community in India or elsewhere. So if you are using TK related in matter in your inventions, then that is objections which can be taken by the opponent. Sorry. And last one is section 3P, where atomic energy related inventions are not patentable. And of course, the secrecy directions are always issued, and these atomic energy related inventions are not examined, and there is a patent not granted for that. But suppose by mistake something comes, then it can be objected to. Therefore, in view of all what we have discussed, we should not miss the opportunity of filing pre-grant opposition, because it is open for any member of public free of cost. Anybody think that in the view of the general public good, such invention should not be given patent. He can raise the objection, file pre-grant oppositions. The simple procedure, as we have discussed, is not a court procedure, etc. Is not involving any cost. It is easier to prevent grant of patent. But suppose you fail in this, then matter will proceed to court and revocation of patent will be required, which is tedious procedures. It is avoid damages. Put the patentee on a back foot before grant, because he is trying to gain some benefit of the patent system and appropriately raise the alarm. Then he is always back foot. And for competitors, this is very important, because if they are doing same business, the same field, then if such patent is granted, they will be in a soup. So to avoid that. So this is there. The very famous case of pre-grant oppositions, and many of you might be aware of this, that I will, sir, I can give break after this for 5 minutes.
Yeah.
I
Please
will
go ahead.
mention this case of Gleevag case, which is landmark case in the area of pre-grant opposition. And at the control stage, my friend Mr. Rangaswamy has decided this. He was immediately in limelight to refuse the patent given by patent applied for by Novartis. It was opposed by Natco Pharma Limited with application 602 of 1998 filed in Chennai office. The subject matter was crystal modification of N-phenyl-2-pyrimidine amine derivative process for manufacture and its use. This was a drug used for treatment of cancer. And the priority, I hope you know the priority, it was taken on the Swiss applications of 18/7/1997. And then this pre-grant opposition was filed by Natco Pharma. And the grounds taken were prior publication, lack of inventive step, non-patentability under section 3D. So it was anticipation, that is prior publications, there was no inventive step, so there was novelty. See, look at this, novelty was not questioned. And non-patent, there was section 3D was involved, which is important subsection for raising or protecting the evergreening. To avoid evergreening, the use of section 3D is very common. Now, controller, after hearing both the parties, concluded as follows. He said, the title compound claimed as imitative mesylate, the short name was imitative mesylate, was already known in the previous US patent number. This was cited, right? So this was anticipation. Then claims of the instant invention, claim 6 to 23. Of the prior document, claim pharmaceutically acceptable salt of the base compound. So application of invention was for the salt isomer of the original compound. But in the very parent application, the pharmaceutical accepted salt and variation were already claimed. So it was prior claiming anticipation of the prior patent applications of the US origin. Another document, that is Nature Medicine, also describes the title compound, which was claimed in Indian applications. Also, title compound salt inherently existed in beta-crystalline form, which was claimed. It is not new, it was a part of that. And then, in view of this, the controller concluded that the claims for the product and process in respect of this compound are anticipated by the US patent, which was already granted. So this was one of the grounds which went against the grant of patent. Now next, section 3D. The enhanced efficacy was claimed by Novartis based on the bioavailability of the innovations of beta-crystalline form. And it was claimed that there is 30% increase in the bioavailability, which was too less for grant of patent. And also, bioauditive could not be criteria for judging the efficacy of the invention, which is requirement under Section 3D. Under expansion of that Section 3D, you'll find that efficacy should be there in case of the uh, new form of the known substance, that if unless efficacy is established, patent cannot be granted, and to conclude that there was no efficacy. Thus, there is no improvement in the efficacy. This was concluded over the known substances, and hence the product claim amount to be mere discovery of the known form of the known substance, and hence patent application cannot proceed to grant. This was right conclusion, which was challenged further in the IPAB, then in the High Court, then Supreme Court, but the controlled decision of refusal of the grant of patent to this substance remain intact. It was not overruled. Shall we break for 5 minutes, sir? After this, hello.
Yes, sir.
Can you break and we'll meet at so many things remaining to be covered. So I will speed up and we'll ask the student to join as early as possible.
Yeah, you want 5 minutes, sir?
5 or 10 maximum. 5 minutes sufficient?
Yeah, 5 minutes sufficient.
Okay, I will join. I'm still here.
Yeah,
And you tell me when to start. We start.
yeah,
Right?
3:55.
It's 4 o'clock we can join.
Yeah, okay, 4 o'clock.
Up to
4?
you.
Yeah, our session is supposed to start at 4 only. Yeah. Okay, we'll come back by 4.
Yeah.
Is it okay?
Yes. Yes.
Yeah.
I remain join.
Yes, sir. Okay, sir.
Yeah, please. All of you, please come back by 4.
Thank you.
As I told you, Dumane Sahib is a walking encyclopedia. You know, we are a walking encyclopedia for IPRs. So we have got a library
It's a great place for me, sir. I'm embarrassed.
No. Since I have been getting benefit and seeing you, that's what my personal belief. So you have hundreds of slides in your one deck. So depending upon the requirement you choose, that is a great, good practice for all of us. We should have a complete deck of slides for the entire IP as a whole.
Yeah. Yes. True.
Ganesh. Sir, once you are ready, please.
I'm ready, sir. I'm ready.
Okay, let us start then.
Okay. Yeah. So we have finished the pre-Ghana position system. After pre-Ghana position, is it, I'm audible or everything is okay?
Yes, sir. Yes, sir.
Yeah, it's
Yeah.
okay. Sorry, please go ahead.
So after pre-Ghana position is disposed of, patent is granted, under and then post-Ghana opposition, if any, comes into picture. What happens after grant of patent? As soon as patent is granted, that is the controllers uh, in now it is electronic system writes that patent has been granted. From that date, there is no delay. Although it may appear in the journal, that is also electronic, the patent is granted on say Monday, and it is published in the electronic journal on Friday. As per the rule, within 1 year of publication of the patent grant, opposition, post-grant opposition can be launched. But with this 5 days or whatever difference is there, for the post-grant opponent, it will be 1 year plus 5 days as available. Because the wording in it is from within 12 months of after publication of grant. It is not after grant, it is after publication of the grant. So, yeah. So, pre-grant opposition can be filed. We have said 1 year of the grant. Then, on the prescribed grounds that also we'll see, which are similar to pre-grant opposition grounds, by giving notice of opposition to the controller. Up to this point, is similar, but nature of notice is different, and this time is fixed. This is only after publication of the grant. Within 1 year of this, the 1 year period is not extendable. Can be filed only by the person interested or interested person. This is the difference. Of pre-grant, there was no such requirement. Anybody, any member of the public can file pre-grant, but here, person should be interested, eligibility criteria. Other persons, if the person is not interested, also great skill he has used for filing post-grant opposition, it will be thrown away, not considered by the controller. So, first of all, during the proceedings under post-grant opposition, the opponent has to establish that he is the person interested. If there is objection by other party that he is not eligible to file the oppositions. So, what is person interested? Defined under section 21T. That is, includes the person engaged in or in promoting research in the same field as that to which the invention relates. For example, if it is related to mobile, the person should be interested, should be dealing with that field, either in marketing or production or in research. It may be an organization that has manufacturing interest or trading interest in the patented article, or which has financial interest in manufacturing such goods, or which possess patents relating to same subject matter. The organization which is also having interest in the same field, they possess the patents in the same field, and they uh, they think that by this, when this patent will remain in the field for a long time, it will hamper their interest. so they can file post-grant opposition. For such,
Sir, here is a doubt, sir.
yeah,
So here, the post-grant opposition should be filed within the on a year,
uh,
and an extension of time to file the notice. What is the
yes.
difference between?
Within 1 year, the 1 year period is not extendable, is what I mean to say.
Okay.
Yes, that's
Got
right.
it.
Because after 1 year, another mode starts, that is revocation of patent. That is also like post-grant procedure, but that goes up to life of patent. Means till patent is valid. Any revocation proceeding can be brought before the High Court and not before the Patent Office. So for the Patent Office proceedings, this is the second opportunity available, that you can take proceedings against the patent granted, but that is before the High Court. That is the meaning. Right?
So, the entire life of the patent, one can ask for revocation.
Yes, yes, yes.
So, whereas
Definitely.
in the post-grant opposition, only within 1 year of the grant of the patent only you can oppose.
Yeah, and that is also revocation. Post-grant opposition is against the patent. Then also it is said patent is revoked.
Okay.
Right? And this appeal procedure was available in the IPAB, but now IPAB does not exist.
Yeah, High Court.
So against the control decision, one has to go to High Court only. That is commercial courts. Right?
Right, sir. Right, sir.
Yeah. So this difference, as we have discussed many of them, the differences, the only only thing that the post-grant opposition is more like a court proceedings, and pre-grant opposition is an informal proceeding. That is why it is called representation. But it is a cautious judicial process which goes on before the controller in case of post-grant oppositions, because costs are levied on the parties, all such things like any regular proceeding in the court. So court is judge for that person, for that matter, in the post-grant opposition.
Sir, can you please go back to the 41 slide number? I think you have missed. You have skipped that slide, but I think the research, the
Just to say,
participants.
yeah, because I will explain that. That's just your time.
Okay. This is very, very important, dear participants. To summarize, the pre and post grant opposition, they are very critical steps in the prosecution process. So you should understand the difference between a pre-grant opposition and post-grant opposition.
We
Can you sum-
understand you are opposing the grant of the patent. In post-grant, you are opposing the patent granted. The major difference. Right?
So there are many pending cases, this is also a very active profession for some people.
Yes.
Opposing and at the pre-grant and post-grant.
What happened, a real thing I am telling you, when I was in Chennai, during the initial period before this, Snehalata Gupte and others were President of India, is a famous case, which finally decided that there should be no room for filing multiple pre-grant oppositions. Right? Before that, once patent was granted by some granting section, it went to register of patent section. Means to make entry in the register, the patent has been granted, right? And then publication. So there was a gap of time between the patent grant, actual patent grant, and publication of the grant, and that gap was more than few days or even 1 month or 2 months also, right? And during this time also, when there was no publication of the grant, the pre-grant oppositions were filed and manipulated. I have seen such things. So, in the good faith, suppose somebody accepts the pre-grant opposition because patent grant was in journal, then it was a great trouble. And one of my closest friends from Chennai, controllers, suffered from this. The examiner now, who is a head of patent office Chennai, I am a controller friend who presumed that it was filed before the grant and treated his pre-grant opposition while landed in trouble. It was inquiry against him. And I understood what happened there, but for the other persons, it was a manipulation of the system. And those two poor guys were in trouble. But because I was chief vigilance officer for the entire patent and trademark or copyright offices, matter came to me, and I gave this the benefit of circumstances that they did not behave in the manipulated manner, and their intention was very clear. There was no mistake on their part, and in my capacity as a CVO, I exonerated them. Otherwise, their whole career would have been in trouble. A small interpretation. Thereafter, really, in 2013, the decision of the Supreme Court came, where as soon as the controller grants patent in the file or electronically, that is a grant of patent. There was no further time available for filing any pre-grant oppositions. This was the ruling, and all this process stopped now, right? So therefore, it is important procedure.
There could be a question in your examination on Saturday from this table, you know.
Yeah.
So will there be a fee for a pre-grant opposition? When you file an application in Form 7,
Yeah, this came as a representation in the stakeholder meeting also many times where when I was active in the patent office and control general office, we vehemently reject that demand because the very motto purpose of the pre-grant opposition was to assist to the patent office to give correct patent, right patents, right? It was not coming in the way of procedure, but it was helping the procedure of grant by the patent office. So there should not be fee. People should not be levied fees. And they should be allowed to come forward to raise the issues. So fee is ruled out.
and I am telling the participants to remember that there is
Yes.
no fee for opposing pre-grant opposition. However, there is a fee for post-grant opposition.
Yes.
So there could be a question in the examination on this point. I am telling them.
Yes.
In the multiple
Yes.
choice questions,
Yeah.
one of the possible question is that is there a fee for applying for a pre-grant opposition? Yes,
Yes.
sir. You can continue,
Yes.
sir.
Yeah.
This slide given a complete information about this pre-grant and post-grant. Very useful slide. Could have missed it.
Thank you.
Thanks for.
But I have already explained. So I was going ahead.
Yes.
Thank you for reminding me.
Last 10-15 minutes is summarized in a single slide.
Yes.
Yeah, please go ahead, sir.
Oh, okay. The grounds are similar as I told you, exactly similar wordings are there. The difference that there is a patent. So this pertains to patent granted. After patent is granted, post-grant opposition will come into picture. That is the meaning. Now, what is the procedure? Same opponent shall file notice of opposition in Form 7. Fees is to be paid and the statement based on facts and evidence, and the copy is to be sent to the patentee here. Now, not the applicant for patent. And controller shall notify the patentee that look, against your patent, the post-grant opposition has been filed. Right. And it is up to the patentee to contest the opposition. So this is very important provision. If he desires to contest the opposition, he has to file the reply statement based on the opposition's version of this statement and evidence. And he has to, ground by ground, he has to refute that, look, my patent is valid. Now, and this he has to do within 2 months. And then after receipt of such reply from the patentee, opponent has again chance to file evidence reply within 1 month. Because what happens, it may be possible that the patentee might have raised some another citations, all that in support of his claim that my patent is valid. Now, therefore, some chance is given to opponent again to give evidence and reply in evidence like this. So evidence in reply by the opponent shall be strictly confined to matters in the patentee evidence. Of course, if he has raised the new issues in his reply.
Sir, can you go to 42? Just I missed it.
Yeah.
There was a phone call. I'm sorry to bother you.
Oh,
Just,
no issue.
yeah, yeah. This is grounds for post-grant opposition. This is also very important question for students who are
Yeah.
appearing for the examinations. What are the grounds for pre-grant opposition? What are the grounds for post-grant opposition? This is a very standard question in a subjective examination. Of course, in objectives may one or two points may be covered, but in general, in any patent examination, what are the grounds for pre-grant opposition? What are the grounds for post-grant opposition? These are the very standard questions.
And this is the abridged version of the text available in the actual section. Abridged version.
Yeah,
And you will find that always the patent word is used there, their invention or application word is used there. And other matter remains same. Right?
right, sir. Please go ahead.
Okay. Now we have seen that patentee desires to contest. Now, if the patentee does not desire to contest or does not file his reply and evidence within 2 months, what will happen? His patent stands deemed to have been revoked. Look at this. If patentee fails to reply within 2 months to the statement evidence of the opponent, or he does not file at all, the controller has the power to revoke the patent without any further proceedings, which is very important for the patentee to submit some reply so that he has a chance to defend his patent. Right?
Javan? చెప్పండి హలో గుడ్ ఈవినింగ్ చెప్పండి
So, after receiving the reply from the patentee, in reply to opponent version, all these are referred to opposition board. Here, this is very big difference between the pre-grant procedure and post-grant procedure. In pre-grant procedure, who is the deciding authority? The controller under whose supervision the patent application is being examined, and report of the examination submitted by his examiner to him. Same controller will decide the fate of pre-grant opposition, which is contrary to here, because the rules have been made that post-grant opposition will be allotted to different controller and not the controller who has granted the patent, because human tendency is that he will defend his own decision. So patent opposition, post-grant opposition is referred to the different controller than the person who has granted patent. Now, that controller, what he will do, he will set up the opposition board, because he is the opposition board will advise or suggest as to how to deal with the instant post-grant opposition. So for that matter, the opposition board will have 3 members, and one of this will be chairman of the board, and it may include the examiner also and some assistant controller. So 3-member committee, which the opposition board will examine all these opponent version, reply by the patentee, again evidence in reply by the opponent, and original application as filed by the opponent, right there. And all these are examined by the opposition board. Within 3 months, they have to submit the report. And board shall submit the report as joint recommendation. It is not just suggestion, it's a recommendation. That elaborating upon the reasons of each ground. So examination, opposition board has to take into consideration every ground, what is being told, cited by the opponent, what is the reply of the applicant, patentee, and what is the recommendation to deal with that, whether that ground is established as a ground of opposition or not. This also opposition board has to write in the report. And then after it is allotted to opposition board, normally there is no further evidence is allowed, and if express request is made by either party that this is the further evidence we want to submit, then the controller's approval is required. They cannot submit suo motu. So controller can permit submission of any extra evidence based on the circumstances, based on the quality of that evidence, and if that evidence is submitted by the either by either party, then this is also referred to the opposition board. Now opposition board is having entire thing. They have recommended. They have submitted report. The next step will be the control. It will go to controller, who is the deciding authority. Then there are three options before the controller, as like the pre-grant opposition. He will maintain the patent, or refuse the or revoke the patent, because the refusal stage is in pre-grant. It's the revocation stage, or he will ask to amend the to maintain it. All these three things can happen. And speaking order again is issued. Right? This was regarding post-grant positions. Some cost can be added in the decision also. Basically, it is speaking order which is published in the database of the parent office, that is ipindia.nic.in. You will find under decision of the controller this under pre-grant opposition or program opposition, all are available for the reference. And this decision of the controller can be challenged only in the High Court. Right? Now we come the third part, that is revocation of patent, which the time limit is up to the life of the patent. So patent may be revoked by the High Court only, court or commercial courts like that. Of any person interested or of the central government, means petition to be made by any person interested, means aggrieved party by virtue of the decision given by the controller. That is, person interested will approach the High Court for further relief, right? Or central government may also apply to High Court for revocation of some patent, that we will see in the elaboration. Or on a counter claim in the suit of infringement. What happens? See, there is infringement of patent. So naturally, the aggrieved party, that is the patentee, will apply to remove that infringement. So he has to apply before the district judge that, look, my patent is being infringed, and then that I should get compensation or infringement to stop. Now, at this stage, the alleged infringer will go to High Court alleging that whatever patent has been granted is not worthy of remaining in the public domain. It is invalid patent. So he would question the validity. So as soon as this validity of the patent is questioned, this matter is transferred to High Court. So High Court has the jurisdiction to speak on this. District court procedures are stopped, including the compensation being asked for. Every matter goes in the High Court. There are grounds which are similar in the post-grant opposition for this, but there are extra grounds also. So, for example, these are the grounds prior claiming. These are given in Section 64 of the Patent Act.
Sir, Domana sir.
Yes.
Yeah, just come back to the previous slide. So here, actually, the basic ground for giving a patent based on the novelty and the invention and the industrial applicability.
Yeah.
So by checking all these three conditions, they are given in a patent, right? So the patent is granted, then the revocation of the patent is section section E and F. This is already satisfied, then only given for patent.
Very good question, sir. I understood what you want to say.
Yeah.
When this search procedure, elaborate mechanism, everything is available to the examiner and controller before grant of patent, then why should there be doubt?
Yes, sir.
About lack of novelty and industry, right?
Yeah, correct.
But in any patent offices in the world, the validity of the grant of patent is not guaranteed.
Mm-hmm.
Because two things. Search is never complete.
Okay.
there are limitations for conducting search
Mhm.
of anticipating documents. This is one thing.
Okay.
So, under section 13.4, you take out that the validity of patent is now granted. Category is mentioned in the patent act also. So, there remains room for any doubt to take doubt about the novelty inventive step. Right? Third thing, there was a provision to submit the models of the invention to the controller. Even if this procedure is not now there, although it is mentioned is there, but during my career I have not seen any controller asking for submission of the actual apparatus or device or model of the invention. So the controller, while granting patent, has to rely upon what has been said in the paper submitted before him, without verifying any validity of the procedure or device, etc. Whether it will work or not, whether that has been made or not, like this. Therefore, the opposition procedure is still there that this invention is not likely to work. It has basic ingredients that it is going to failure or something like that. During discussion, this thing comes. Now you understand that validity of patent is not granted, so there these doubts against the capacity or then capability of working also. So all these grounds are therefore mentioned that although patent has been granted, it is not novel. It was earlier there, unlike, uh, but then nobody can take objection to patent is not working properly. Why? Because Act itself says that by grant of the patent, validity of patent is not granted. So you cannot challenge that this patent is not giving the result which has been claimed. Only thing you can ask for revocation of this patent. And you cannot ask for compensation of also that I tried this procedure and I failed. You got the point, sir? Hello?
It is a great insight,
Yes,
sir.
sir.
We
Yes.
were not knowing that once patent is granted,
You just try to read section 13, subsection 4.
okay. So it can be,
Or-
can be.
Yeah. The examination and investigation required under section 12 and 13 shall not be deemed in any way to warrant the validity of any patent, and no liability shall be incurred by the central government or any officer thereof by reason of or in connection with any such examination or investigation or any report or other proceedings consequent thereon. Right, sir?
Yeah,
So,
yeah. That means he has been protected for his actions.
sir, what?
He has been protected by
Yeah,
the act.
yeah, of course.
Yeah, in a good faith. If
Yes.
he
So
has taken.
in view of this, so you cannot sue the controller of patent office person. That matter, for that matter, patentee also, that patent is not giving results like this. And you will also surprised that in US patent office, between say in the end of 18th century and beginning of the I think some 19th century, you can say, for over 40 50 years there was a practice of submitting models of the miniature models of the invention, and they were beautifully made artistically. So one officer of the US government thought that all these should be exhibited. So they stored those all the models of devices, including say old patterns, Newtons, patterns, not Newtons, other say Singer machine or like that, in the exhibition, and is nicely and subject-wise placed. This was a great tourist attraction. Over 3 lakhs models and it gave the progress of the technology of the US through those models. This was true. But one day what happened, all these were caught by the fire, and then lakhs, 1 lakh or more than that models were now destroyed. So they discontinued the process. USPTO discontinued the process of asking the model to be submitted. Right? In USA also this procedure is not there, but it was there previously. In our Act also there is a provision to submit the model, but nobody insists that. Because if the controller wants, this wording is there. It is not mandatory. So I have not seen any controller asking for the model to be submitted. Is clear now? Sir, any doubt about this now?
Yes, yes, sir, please.
Okay, okay. So we have taken so this is the normal revocation under 64 on any of the ground. Normal petition is to be filed in the High Court. High Court consider all aspects and revocation in mechanical engineering or electronics or in drug. These are the fields where revocation has occurred in the past. There is separate provision for revocation of the patent in public interest. What happens? Controller has granted patent without realizing the basic effect of their implement. What will happen if this was, say, in the public domain used by people? Whether it will limit the rights of the people, all these things patent controller has not taken into consideration. For such patents, under 66, there is provision where the central government is of the opinion that a patent or its mode of exercise is mischievous to the state, generally prejudicial to the public. It may, after giving the patentee an opportunity to be heard, make a declaration to that effect in the official gazette, and thereupon patent shall be deemed to be revoked. This happened only in one case, or two cases, rather in 187 also, but recently in 2013, one patent which was granted for a diabetes drug for AstraZeneca laboratory. This was a mixture of herbal extracts of 3 plants, and such patent was granted by the controller. It was claimed that if this patent is granted, it will affect the millions of people, and patent itself is invalid because each one of these plant was having the property against the diabetes, all 3, and then improvement was very little. Still, it is monopolized in public interest or it is mischievous to the state. So, on application by the member public, this patent was revoked under section 66. This is a story. You can get information by googling it very easily. Now, revocation of the controller by the direction of the central government, particularly invention related to atomic energy for which no patent can be granted. Again, by mistake, suppose patent is granted, that if any interested person applies for against this, patent can be revoked by the central government. Now, revocation before High Court, any person interested or central government may make a petition on any ground under 64, normal revocation. You can use any of the ground which are mentioned in 64, and a patent can be revoked. Again, a counterclaim also. And suppose you know that there is provision that any patent which is granted in India can be used by the central government for its own purpose, or it can be acquired by the central government for its own purpose. And then if there is some गड़बड़ करता है, there is some resistance offered on the part of patentee, then such patent can be revoked, or he is not trying to get this, he is avoiding giving information, then straightway patent can be revoked on the petition of the central government in such cases. Then this is special case. In case of when this company license is given after 3 years of the patent grant, then the central government or any person interested may apply for revoking the patent on the following grounds. That is because the person through whom license has been given is not taking efforts to produce the intended goods. The patented engineering has not been worked in the territory. So the very purpose of granting company license is defeated. In that case, any third party, interested party will apply for revoking the patent and let it be in public domain so that the requirements of the public are met.
No. Sir, once again here, what is here compulsory license?
Yeah, we are going to look into that in the remaining time today itself.
Okay.
So I'm going slightly fast. Okay. Actually, I'm skipping that. What you call? Yeah. Revocation description. This is just an example of the revocation of patent which was based on traditional knowledge. This is particularly happening in Himachal Pradesh and Uttarakhand, where the ladies, particularly, they carry these type of baskets of collecting fruits and flowers, etc. It is going on so many years. One company is uh, applied for a patent of more sturdy and plastic type of container, and controller was foolish enough to grant a patent for this without taking into consideration the traditional practice which was occurring for hundreds of years, right? And then it was challenged, of course, uh, by another manufacturer who was manufacturing this type of baskets called Kilta, and High Court revoked the patent because general public was put to loss by such patent. It was revocation case. So I will now go to the second part, that is working of patent. We are elaborating on the um, more cases because time doesn't permit for that. So we'll go straightway to working of patents. Is it okay, sir?
Yes, yes,
Yeah.
very important section. Yeah.
Because working of patent and company license are linked together because section 83 of the Patent Act describes the what are the objectives of patent law, right? So objectives of patent law for implementation in India is first is to encourage inventions and to see that patents are work in India on commercial scale and to fullest extent without undue delay. So patents are not granted to just sit on that and not working. The patent must be for the benefit of people within reasonable time. You cannot just get the patent and just be idle. This is requirement. Benefits of the patent should be available to the public at affordable price. If, for example, drug, etc., if drug is patented, then that should be available. Generally, cost is more in initial stage. But and as the, say for example, time goes on, the cost reduces. But it is, if that cost is still very much enormous, then that is not good, and government can enter into that. And patent, if you patent the thing here in India, you are just going into importation, or foreigner gets patent in India, then he will just import those things into India, not manufacture in India. That is also not desired. That is not the aim of the patent grant. Not to impede protection of public health and nutrition, patents should work to support public health and nutrition. And also, patents should protect the public interest and to ensure transfer and dissemination of technology. This is basically done, means ensuring transfer of technology and dissemination of knowledge in public domain by mandatory provision of the publication of patent, invention, application of patent, as well as granted patent both. So there are two publications in patent law. One is before grant, that is publication of application as such, and patent publication of patent, granted patent. What is the purpose? To put the public knowledge, virgin knowledge of patents and inventions before and after grant of patent for the benefit of people, so that people takes encouragement from such technologies and start their experiments to improve upon them, to get new technologies in the public domain, and not for copying purpose, of course. So publication of patents and patented applications is done with the view that it should help transfer of technology and dissemination of technology in public domain to give mutual advantage to producers and users. Means patent is a sort of reward given to the patentee so that he is encouraged to do further research. And what users get? Users get better and cheaper products. Thus, there is a balance of rights and obligation. This, in short, is the objective of the patent law. So, working is working of patent in public domain by public availability of the inventions, and then taking care of public health and nutrition, public interest. All these are the objectives of the Patent Act. So important provision is that Section 83 and subsection A of 83 speaks more elaborately that patents are granted to encourage invention and to secure that inventions work in India on a commercial scale and to the fullest extent that is reasonably practicable without undue delay. So, this is the basis of working requirement of patent, which is given in given in Section 146 of the Patent Acts. It is provided in that section that the controller has the power to call for information such as periodical statements as to the extent to which patented invention has been commercially worked in India, through the notice in writing issued to that effect at any time during the continuance of patent. So, after patent is granted, there are two rights vested in the controller. One is controller can ask for any information about particular patent, that what is the procedure, what is the stage, and all that, and reply is to be given within 2 months to the controller. So, patentee cannot hide, cannot delay granting information on the granted patent, which is to be given to the patent office. This is one thing. Second thing, the patentee and every licensee shall furnish a statement as to the extent to which the patented invention has been worked on commercial scale. Means regular filing form 27, where information as to what you are doing with patented article, patented product, whether you are working or not, and what are the constraints you are facing for not working. So continuous non-working of the patent for 3 years compulsory license. So it is very dangerous situation if the patentee informs the patent office in form 27 that I am not commercializing my invention, then that patent is open for commercial licensing, right? Provided some applicant comes in to get their patent and start working. And as this their rules governing 146 section has been amended in the year 2021. Previously, the period for which information required to be given was calendar year. Now it is financial year. And after financial year, within 6 months, you have to file Form 27 giving elaboration or details as to what you are doing about the working of patent. This Form 27 we will see. And this first, so 146.1 and 146.2, right? If you do not file Form 27 or you do not give information to the controller as is required by him, or delay it, or give false information, in all the section, all the circumstances, there is section 122, that is punishment for refusal or failure to supply information. It is very, very harsh treatment meted out to patentees. Really, it states, if any person refuses or fails to furnish to the controller the information or statement as required under section 46, he shall be punishable with fine which may go up to 10 lakh. If you do not give information, you are likely to face this situation that you will be fined by 10 lakh rupees. And more important is another, the next one, that if any person be required to furnish any such information as asked for, and he is giving false information, or is not giving information at all, and which he either knows, means knowingly giving false information, and then or does not believe that it is true, means he has full knowledge that what I am giving information is false, then he is punishable with imprisonment, which may be extended to 6 months, and fine also. Why I strike out this? This is the provision. This was the provision rather under section 22, that if you give false information, insufficient information, or delayed information, you are likely to face the punishment which comprises imprisonment up to 6 months and fine. But this punishment has been taken away, has been removed by Government of India recently in the month of August 2023 itself, because it is very difficult to amend the sections of the Patent Act, and for that matter sections of any act, because it requires to be furnished as a bill in the parliament, and then all this procedure went on. You know how the Patent Act was, Patent Act 2005 was passed after long delay from, and say, Justice Iyengar Committee report, before that Bakshi Tekchen report, all this 1970 Act was passed in 72, and after TRIPS agreement it took how many years to effect the amendment. So submitting the bill and getting passed in the parliament is difficult. Therefore, this separate bill was filed. I will show you that provision. Just 1 second. This one. This is called Jana Vishwas Amendment of Provision Bill 2023, that is JVB. This bill was passed by both the houses of parliament, and then on 11th August 2023, it was signed by the president, and now it has become law. Several provisions in different acts. It is not pertaining to IP Act only. It pertains to different acts, including the Patent Act, have been decriminalized through this bill by removing imprisonment provisions and monetary penalties rationalized. So our section 122 comes in that. So as per earlier provision, as I read to you, the failure to provide the information for working statement by the patentee under section 146 shall be punishable with the fine which may extend to 10 lakh. This was the original provision. Now after Jana Seva Amendment Bill was passed, that is JVB bill, the provision reads that the term punishable have been removed now, or failure to file Form 27, that is working statement, has been removed and left with by way of penalty. So punishment and penalty, difference is there. Punishment you are accused and penalty means you are not fulfill the requirement. So punishment word has been removed and is a way of penalty which may extend to rupees 1 lakh. So from 10 lakh it has been brought down to 1 lakh. And if you continue to not submission of this one, then further penalty of 1,000 rupees every day. See, from 10 lakhs it is reduced to 1 lakh, but you continues not for not filing this information, you'll have to pay see 1,000 rupees per day delay. This is new provision under JVB bill. Now next provision, that is section 122. We have seen that it pertains to refusal or failure to provide information when asked by the controller, and you are failing in that. So the earlier provision in case of such thing was it shall be punishable with imprisonment which may extend to 6 months or with fine or with both. This was the original verdict. Now in JVB bill, which became law on 11th August 2023, General Resource Bill, it has substituted the imprisonment provisions with the words, he shall be punishable with penalty which shall not be less than 25 lakhs. So criminal procedure or imprisonment has been removed to put it the high penalty of 25 lakhs. This is the latest thing which is happening in the field of working of patents.
Sir, this Jan Vishwas Amendment Bill, has it been passed, sir?
Yeah. I just read in the net. So it has been signed by the Parliament also, President also. I had read the provisions of the bill earlier. That it was passed by the Parliament, and now on 11th August 23, it has been signed by the President also.
Okay. So, a lot
So,
of financial burden.
Yeah. Pardon, sir?
Lot of complaints.
Yeah, and it is great relief also because it is not justified due to the imprisonment of the intellectual person. And not only that, see, on persistent demand from the foreign patentees and even local patentee, because the provision in the working statement was very hard. Very hard. And so there was demand that the Form 27 format to be changed and certain provisions to be removed. So it was 21 amendment which gave new Form 27 where many things have been provided. It has been very simple and certain requirements which were earlier have been taken out, and you can file in respect of it was not only single patent but multiple related patent also. You can file single Form 27, and agent can also file all these things. So this is the new Form 27 which gives some detailed statement provision also.
Very good evening, sir. This is Kavita recording from Parkworth Management.
Sorry, sir. Just one second.
So the new Form of 27 can if work or not work. If not work, if you click, then you have to give statement up to 500 words. What are the reasons for that? And then if you give the work, you have to give the approximate value of the revenue generated. All this, which is simple. This is not earlier very stringent provisions were there. Now, if you tick at the not work, then following could be the reasons you can give. Due to lack of market potential, market is being developed, maybe work in the future depending upon market, and then the patent is actively working, to develop market for the patented product. The technology may be available for licensing. The patentee is in the lookout of appropriate working opportunities like licensor, etc. Like this. Then previously this was the provision. I will just summarize the next slide. The new Form 27 has many specialities. First, its timeline has been changed. It is now in respect of financial year, and you can file up to 6 months, right? And then key changes have been made. Requires every patentee and every licensee to submit Form 27 for a given patent or bunch of related patents. This is addition. Earlier, for each patent, you were required to submit Form 27. Now you can submit this single Form 27 for bunch of patents. Joint owners can file one single form. An authorized agent can also file single Form 27 on behalf of the patentee or licensee. This was not there earlier Form 27. And more importantly, it shows the patentee, allows the patentee to provide appropriate value of the revenue generated through manufacturing and importing. This was not possible in the earlier Form 27. Allows submitting information in respect of multiple related patents, then it, and where the individual value is not possible to make. Then key positions, key gives some information and it comes out to be false, then you are liable to be punished criminally, or that punishment portion that was removed now also, but it was there, or fine. So ultimately, while amending Form 27, this provision has been removed. Countrywide importation details have also been removed, right? So we stop the working of patent here, and in rest of the time we look into compulsory licensing. Here I just can summarize within time available. Compulsory licensing is a license given involuntarily against the will of the patentee, because patentee has not given license voluntarily, and it has been tried by the willing licensee, but he failed. And basically, it is given in the in an attempt to take care of public health and nutrition, preservation, etc. That is important purpose of giving complete license to the license seekers. What is taken into account while granting complete license is nature of the inventions, time that elapsed before 3 years you cannot give, the measures that which are already taken by the patentee and other licensee to fully utilize the invention. Sometimes license is sought as compulsory license, but already patentee has taken efforts to fulfill the requirements for compulsory license. That is also there. The applicant's capacity to use the invention for the benefit of the public. When the license is sought, means I want compulsory license, but you don't have capacity. How will you do that? How will you manufacture? All these are to be looked into. And applicant ability to take risk, capital, easy having capital available with him to start manufacturing, that is also seen. Now, grounds for compulsory licenses within normal license is it can be granted to any interested party to work the patented inventions or any of the following grounds. There are 3 grounds. Reasonable requirement of the public has not been satisfied with respect to patented inventions, or patented invention is not available to the public at a reasonable price, means reasonable requirement, then reasonable price, and patented invention is not work in India. These are the 3 grounds, and even if single ground is fulfilled, compulsory license can be given. This exactly happen in case of the first compulsory license which has been granted by the Controller General in 2012 in case of Bayer versus Natco Pharma. For 3 years period is there. Before that, you cannot grant compulsory license. Hearing is given, allow both the parties to put up their case. There is another type of license, compulsory license only. This was general license. In very specific circumstances, after grant of patent, central government can direct the controller to grant compulsory license because the notification has to be taken up by the central government that the compulsory license should be given. This happens in case of national emergency or extreme emergency or public non-commercial use under section 92. So government should be satisfied that there is a situation where the declaration or notification can be taken out and situation exists to that effect. And if license under the specific provision is given, then all other normal procedures of the 84 are not required, and it is given
Sir,
immediately.
sir, can you go to 85 again? Just one small clarification. Sir, why this license is called compulsory license? Is there just not a better word?
No, because what happens, these are basically for drugs. So far, only one company license has been given. Provision is there. But this license cannot be given unless the license seeker has tried to get normal license from the patentee. He has to show that I approached the patentee, I requested him, I was ready to give the license fee, but he declined to give me license. So I have no way left but to approach you, sir, to give me license.
Okay.
For his efforts, it is clear that the patentee is not willing to give voluntary license. Therefore, I want compulsory license. This is the meaning.
That is how the compulsory word came into.
Yes, it has involuntary license, and all his efforts to seek normal license have failed. Other terms and conditions of compulsory license, now things is very clear. Now his efforts have failed, and he is seeking compulsory license from you. And after controller is satisfied that any of the ground is fulfilled, then he can issue the compulsory license to the applicant. While granting a license, the controller shall secure that royalty and other remuneration reserved for the patentee are reasonable. For example, in ATCO license, 6% royalty was fixed to buyer. Patented invention is work in India to the fullest extent by the licensee with reasonable profit to him also. Yes. So, in the application made by this situation might have been explained that patented invention is not available fully. So, it is responsibility of the licensee to ensure that this requirement is met. Patent article is made available to fully affordable prices should be affordable. This was specifically taken into consideration while the license was given for the time to NATCO. License granted is a non-exclusive license, means others can also be given license for the same subject matter if the single licensee is not able to fulfill the requirements.
Sir, one more doubt.
Yeah.
During pandemic, COVID pandemic,
Yes.
why this compulsory license was invoked?
Yeah. Compulsory license for which drug?
For vaccine, for example.
No, that was say nobody had applied for compulsory license for that because
In the government, there is a provision, sir, when there is a national emergency.
that is a different. That is used by the government and acquisition by government under section 99 and 100. This was tried, right?
Since
But-
there was a pandemic and public.
And it was in discussion for a long time. But final report was submitted by the DPIIT in the Supreme Government, that is in the government, the Supreme Court. that technical know-how transfer along with the patent is very important aspects, and it will not lead to immediate manufacture which is required. Even if complete license is ordered by the government under section 92 or 100 also, then it will take time for the new entrant in the field to start manufacturing and all that. Because patent for starting the manufacture, only patented invention may not be sufficient. Actual technical know-how is also important. The government has very much doubt that if we rely on this, firstly, it will create the bad image for the government that they are uh, giving license. The second thing, it may not be technologically viable to produce it and supply in very limited time which was available with the government. So that report, which a reply in the sense, reply to Supreme Court was provided by the government that this option may not be considered, and say um, other options were sought. You might have read this news. Hello, sir.
Yes, sir. Yes,
Yes,
sir.
sir.
Yeah.
This report was submitted by the government.
Okay.
Sir, Dumane sir,
Yeah,
sir, why technical know-how is needed? Anyways, for
Because-
patent, there
yeah.
is obligation that specification should be, we should
Complete
satisfy
specification.
enablement and best mode, right?
Now that is a typical patenting procedure. In the drafting, I think you might have learned about this. That drafting of patent specification allows you to claim in slightly broader manner, and that it is not like a publication of paper where each minute details are also given. It is a say broad range is also claimed. Although patent the best method is supposed to be given, but it is general experience that unless that is supplemented by technical know-how, then complete picture of manufacture will not emerge. In fact, yesterday only I was reading some 5,000 patents have been summarized, examined by one great author, and he has come to conclusion that the working method and all that whatever is claimed in the specification need to be revisited for starting actual manufacturing procedure.
Then the purpose of bringing a patent act is of no purpose is served.
No, no, it is serving purpose. This particularly is valid for drug patents. You see the Marcus type of claims, how they are granted. Patents grant to Marcus type of claim where lakhs of molecules are involved, and method is described only in this way few molecules, right? And which one will be more useful, it is not given. But patents are granted on Marcus type. But definitely, this happens only in public health and um, pharmaceutical patent. That you need to have some technological know-how.
Right, sir. Right, sir. Maybe in that case, why can't a controller can request for the working model or something like that? Maybe especially for the drug-related patents or something.
But this is general experience that it requires technical know-how by virtue of the drafting system, claim portion. It is there. And- But then actually when license is taken, we suppose for manufacture of certain item, is the company should cannot resist the technical know-how transfer also. They have to give it in general way. But then all this negotiation, all this is a third party agreement without involving any government system. Government will get involved only, say, for example, and Section 84 license is also third party license. It is not licensed to government. Government license is only for Section 92 and then Section 99 and 100, where patent will be taken over by the government for its own use.
Sir, section 10.4 and 10.5, as you are mentioning,
Yes, exactly.
it's supposed to give the full description of the inventions so that any layman or any person skilled in the art supposed to reproduce that. No, then uh, this entire thing is very confusing now. What is the point in learning about patents, filing patents,
No,
and
sir.
at the end of the day,
This no
and
no this sir, this may be what I am telling situation. Company license is mostly for drug or pharmaceuticals. In pharmaceutical, say it is not one molecule or one derivative is patented. With that, several are there, and which one is more effective? It is trial and error we have to do, which is difficult again. And further, for any drug which is patented, clinical trials are also required. First phase, second phase, third phase. And this is not clinical trials, these are not part of the patent. Clinical trials, before that patent is granted, right? You might have seen clinical trials, you need not go to all discrete trials and experiments. So unless they are clinical trials, drug is not finalized. Therefore, this technical knowledge required.
okay.
Particularly for pharma patent. I'm not talking about other inventions. Other inventions may not require this elaborate procedure.
So the clinical trials comes under the know-how part.
Yeah, the data is it. Data,
Data.
yeah, there.
Okay.
Because I have not seen any complete specification which has given clinical trials.
Yeah, yeah. In the patent claims, we never talk about clinical data and their trials.
Yeah,
Results.
yes.
Yeah, we talk about only the proof of concept about the
Yeah.
molecule.
But it does not mean that patent system is bad. Don't get discouraged with that one. Because see, 90% things are there, and 10% you have to try yourself or negotiate many times for other institutions.
Anyway, you are paying the licensing fee, royalty, and all those
For
things.
example, say sir, for Monsanto, you might have heard, na?
Yeah, yeah.
Monsanto had a patent for what?
Yeah, the
For gene.
seeds,
No,
right?
no, sir, no. Monsanto never patented seeds.
Yeah,
Monsanto patented only mutated gene.
with genes, okay,
Yeah,
mutating genes, okay.
that one. And then which was supposed to kill the this insect
Germination, yeah.
germination. Now after that, the elaborate procedure was to how to develop seeds from that. And there Monsanto came into picture. They did this and licensed their technology with a trade fee like that. It's again misnomer. So all these things happen. So with the knowledge of gene, nobody could prepare the seed. The moment you use gene, this propriety comes. You are not permitted. All this. Okay, sir.
Okay.
So license can apply to control get license. Another patent, if he is hindered to work the patented invention, he may need two or three patents together, and he can terminate license also if not work. That also provision is there. So we will see actually the case. That is, do we have that much time available with us?
Yeah, maybe another 5 minutes. The
Okay, yeah.
people already started leaving.
5 minutes only.
Yeah. Or how much time you want, sir, so that we can request?
We will just discuss the first compulsory license which has been given. Na?
Yeah,
Very
yeah.
important thing.
Right.
Fire versus NATCO. That is last leg of presentation. And then the
I think this is the only compulsory license happened in India.
yes. And other two have been refused for various reasons. Because compulsory license is given if prima facie case is made out to the controller. That all these three reasons, three grounds we have seen. And in view of those three grounds, the applicant has to make out a prima facie case. For example, it is not work in India, he has to prove. Reasonable requirement is not made, means affordable price, that also is to be established. And it is not available to large extent of people, that also you have to be the data of each requirement. That is, establishing prima facie case of grant of company license. This is said. So this could be established in case of this license, but other, I think there are 5 more applications, BDI Pharma, Lee Pharma, they could not establish the prima facie case for grant of company license. Therefore, the Control General rejected those applications. Right? In this case, the Bayer Corporation is Germany based, patented sorafenib, an active pharmaceutical ingredient used to treat liver and kidney cancer in India. Patent number 215758. Nexavar as it is called, the brand name. In 2008, the Indian generic company CIPR began producing and marketing sorafenic tablets with the brand name sorafenic and a description sorafenic tablets 200 milligrams. So this was infringement action. Clearly, they have made some procedural changes, etc. But since the drug patent invention was similar and CIPR was doing that, it was the considered infringement action, and lawsuit was filed against CIPR by Novartis. Bayer charged to 2,80,430 because what happened? Why this was filed? Because Bayer was getting this drug into India only through importation from Germany. They did not set up the plant here in India, did not try to manufacture in India. So working in India was ruled out. And they were selling this drug in India at the cost of 280,438 rupees, Indian rupees, for a monthly course. So this was beyond the reach of many patients, 2,80,000, more than that. While CIPR generic version cost 27,960. It was clear cut copying only. Of course, modified copying you can say, or the same number of tablets. Another generic producer, but meanwhile what happened, CIPR was given license to manufacture by Bayer. There was something happened between CIPR and Bayer. Meanwhile, another generic producer, Natco Pharma Limited, submitted a request for complete license against Bayer's patent on the sorafenib before the controller of patents. During the continuing dispute between CIPR and Bayer, because CIPR was infringing patent, as alleged by Bayer, there was infringing suit filed. This case was going on. Meanwhile, under Section 84, the complete license was sought by Natco. So in this case, it was a prima facie case was made out as per the ruling of Control General, as all the requirements were there, that is not work, requirement public was not, which was available to only a limited number of patients. Other patients could not get this drug, and it was not work in India also. So having thus establishing prima facie case, and then controller observed that the Bayer had failed to meet the conditions of Section 84, the controller determined that Natco Pharma deserved a forced license because Natco has established prima facie case for granting license, and since Bayer is not giving license to Natco, it was a case of fit for company license. The company license terms and conditions were drafted by the controller, who also handed Bayer a 6% royalty. There's a huge argument and other citations, etc. during the hearing by both the parties. But controller decided that each ground was fulfilled by was available for company license, as Bayer was failing in fulfilling requirements of sufficient quantity to the larger number of people, and it was not work in India also. So this was the decision of the controller. The controller awarded the company license to um, NATCO. After this, buyer went to IPB. That time it was existing, claiming that the company license was unnecessary because the medicine was already available at cheaper rate. So the CIPLA, they were target of Novartis, this one uh, buyer, uh, for imprisonment action for saving from the company license. They projected in IPB that CIPLA were their partner. See that it was of course not accepted by the IPB. As a result, buyer contend that if a drug is available on the market at reasonable pricing and is not required patentee, it is then Section 84(1) of the Patent Act will not apply. That is not available. Then IPB, on the other hand, dismissed the claim, stating that buyer was not the one selling the drug at the reasonable price, especially because buyer had a lawsuit. They were in fighting mode, and it was CIPLA who is selling, and buyer was not selling. They were selling at 2,80,000. In order to avoid the company license, only the patentee must avoid the grounds that are mentioned under above Section 84. It's just to the attempt to avoid the grant of company license. Therefore, they brought forward name of CIPLA that they are partner and reasonable requirement has made, etc. So it was not true. Then they went to High Court, who buyer. The main legal issue before the High Court was whether supplies by patented drug in infringers, that is CIPLA, had to be taken into consideration in determining whether the reasonable requirement test was met. As a legal matter, the court determined that patent holder, either alone or through the licensees, has a responsibility to meet the reasonable requirements of the public and not the infringer, as was claimed by buyer. The matter went to Supreme Court. The Supreme Court stated in dismissing buyer's special leave petition that in the facts of the patent case, we are not inclined to interfere. The Supreme Court petition is dismissed, keeping all the questions of the case open. As a result, the Supreme Court ruling restores the uncertainty that had previously been associated with the grant of company license. Thus, at all forums, the company license granted by the Controller General, stating that all three grounds of company license were met by virtue of the citations and arguments made before him, and the fact that it was very costly, 2,80,000. It was accepted by the Supreme Court also, as NATCO was ready to provide the monthly dose at 8,800 only. So the company license given to NATCO was maintained. Other two applicants failed in getting because they could not establish the valid case of PMFC case. Lee and BDI Pharma. I think we should stop here. Dr. Purushottam.
Sir, we got the basic concepts of what is compulsory license, and you have given a wonderful example. I think probably,
Because it is that much delay, time is not available with us.
that is true.
That is the main thing, sir.
Yeah,
I would have loved to give more details.
yeah. We'll get the opportunity in future, sir, to extract the knowledge from you.
So I thought that at least I should discuss the only license given by the patent office.
Yeah,
If you now cannot discuss these other details.
that's true.
So we are stopping here, sir.
Yeah.
I don't know how you like this or not. Or
No. The entire cream of our course is delivered by you only. I would say, because so we only outer layers we spoke till now, but what happens in the black box of Indian Patent Office, you explain with your own examples and with your own experience. No, all of us now we have been only talking theory, but you brought to the hands-on experience and your own application of knowledge. It was really wonderful, and I hope all our participants agree with me. We got very, very good knowledge about anticipation, opposition, revocation, working of patents, and compulsory license. These are all very, very essentials of the Indian Patent Act, and I think no one else could have been done this job so well other than you, because you spent your life in the patent office.
Thank you, sir.
So most of these terminologies, even though we have been working in this area, still not clear. Anticipation means that we are going by the original literary meaning of anticipation. The anticipation in patent law is different, For
Yes.
evaluating the novelty, there are some do's and don'ts. Basically, they are the anticipation, You should not go by the real meaning of English meaning of anticipation.
Yes. Yes.
I feel it is a different thing. So, like that, you brought out the very broad concepts and very complex concepts. All these 2 lectures, we have been, I'm sure all the participants agree with me. We got the best out of you, and the knowledge, the complex knowledge of, the processing of happens at Indian Patent Office related to securing a patent, particularly the pre-grant, post-grant. Very, very important, the provisions what have been made in the Indian Patent Act. And then one important aspect I could see is that you also covered the rules and sections with each of those things. That is very, very important. Talking without referring to the sections and rules, it doesn't give that kind of a fullness to the topic. As a lawyers, there are some lawyer students, participants are also there. They also get the benefit of connecting the inventions, the patents into the IP law, the patent law. I'm very much thankful to you, sir, for your excellent lecture, and we look forward for your continuous blessings, support, guidance to not only to Andhra University, even across the country. I know the kind of services you are providing, the kind of support you are providing to the IPR fraternity as a whole. We get a lot of inspiration and motivation from you, even at this age, and you work like a student. And that is what.
Thank you, sir. Thank you. Thank you.
we
Thank
get,
you very much, sir.
Thank you very much, sir, for your patience and commitment for the development of IP in India.
Thank you, sir.
Sir. Thank
Thank
you.
you. Thank you,
Any
sir.
questions? I think 1 or 2 questions.
Any questions? Yes.
Friends?
Sir, Ravindra Prasad here. Yeah.
Yeah, Mr. Ravi, please go ahead.
Just as a common understand, let me just recollect my understanding. From your lecture, actually, I got it, the post-grant oppositions, there is a three members
Yeah.
team, right? So, controller, chairman, and examiner. Am I
No, sir.
correct?
Controller who hears the case is supreme authority. He's a judge, for example. To assist him, there is opposition board, which comprises 3 members, and examiner can be one of them, and one controller, assistant controller, or some that independent unit. He is not. It is not hearing unit,
Okay.
and job is limited to give recommendations to the hearing officer. Of course, observation of the opposition board are also required to be communicated to the parties. That is also now made mandatory as per the law. But two entirely different. The decision will be given by the hearing officer only, who is not the same controller who had granted the patent. That is important. The office has taken 3-4 years back.
So the point is that the controller who has rejected or granted, he will not be part of the proceedings.
Yeah, He
is
will
the
not be
point.
judge. Somebody else in the same field.
Like in the court also, no, a judge has given a judgment,
Yes.
whether in a division bench, if you go against a single bench, he will not be party to that. So the same way here also.
He is a deemed recusing.
Yeah.
Okay. Thank you, sir.
Thank you.
Any other questions? We are already behind the schedule by 35 minutes, 30 minutes. Doesn't matter. Always, it is a pleasure listening to you and learning from you a lot. Anyone else? There are no questions. We will call it a day, and
I think
tomorrow.
subject has been understood well by all. I hope so.
Anyway, it is in one class is difficult, sir. They have to
Difficult, yes.
undergo 2-3 classes of this nature.
And the topic I covered are per se very difficult to understand. I know.
Yeah, exactly. So they should attend in future some 2-3 classes like this. Then they will be able to absorb, digest, and catch the terminology. Even people like us, it has taken a lot of time.
Thank you. Thank you. Thank you, sir.
Thank you so much, sir. Thank you for your time and energy. Yeah.
Thank you, sir.
Thank you.
Yeah, thank you so much.
Okay.
Yeah, Anandya, if any announcements you can make for tomorrow's? Dr. Anandya.
There's no new announcement, sir. So we will join again tomorrow at 2:30.
Okay.
We have 2 more sessions tomorrow, like every day.
Yeah.
So that's all for today.
Okay. Thank you. Thank you then. Okay, let us all meet tomorrow at 2:30. Thank you so much.
Yeah, Purushottam sir, just request is that today's is the very, very vast subject and the lot of, actually we expected only some of the fruits, but they are given a basket of fruits.
Yeah.
So that we need to recollect this information, so require some PowerPoint presentation for reference. I think it should be sure.
Yeah, we can only request the
Dominic,
research
sir.
people, but anyway, it has been recorded. I think that will be available. We'll try to get the PPTs also.
Yeah. And yesterday, day before yesterday and yesterday's, today's is pending.
Yeah.
We have already sent email to the speakers asking about the PPTs. We are waiting for it.
Okay.
And to Dr. Dhumane also we have already sent.
Yeah. Please send another remind request today to the manager.
Okay.
Because he has to sort it out, he has thousands of slides in his deck.
Correct.
Yeah, he has to pick up what he spoke,
Yeah.
There's no point in getting all that slides. He may not also like to share. So please, Anandya, write a mail to Dumaneji.
Okay,
Right?
sir.
Okay.
Okay, sir.
Right. Thank you. Thank you very much. Have a good day. See you tomorrow.
Thank you, sir.
Yeah.